Hello, my name is Josh Blackman, and I am the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Harlan Institute Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We're now holding the semifinal rounds. This is match number 5. And then from Dublin Christian Academy, New Hampshire, we have Leah Phillips and Elisha Johnson. And from Lake Oswego High School in Oregon, we have Flynn Williams and Saren Chin. Petitioners, if you're ready, you may begin whenever you're ready.
Mr. Chief Justice, and may it please the court. I, Leah Phillips, and my co-counsel, Elijah Johnson, are representing the petitioners for this case. Because we believe that the Second Amendment protects the right of citizens to keep and bear arms, we ask the court to rule that the state's denial of petitioners' applications for concealed carry licenses for self-defense is unconstitutional. Firstly, because the right to possess and carry weapons for self-defense is at the core of the Second Amendment. And secondly, because New York's proper cause law effectively turns a fundamental right into an exclusive privilege.
Your Honor, in 2016, Robert Nash of Rensselaer County, New York, applied for a license to conceal carry a firearm for self-defense. He did this due to a recent string of robberies in his neighborhood, which showed legitimate concern for his own life. In 2017, Brandon Koch expressed his desire to exercise his right to self-defense for his own personal freedom. Both of these men had no known criminal history. They had received the necessary training to properly carry and use firearms, and both men had licenses to use firearms for things such as hunting and target shooting. And both of these men applied for licenses from a proper licensing officer. Both were denied. New York law dictates that there must be proper cause for the issuance of a concealed carry license, and the licensing officer determined that Robert Nash and Brandon Koch did not have the proper cause to carry for self-defense.
Self-defense is a fundamental right. The founders of this nation guaranteed American citizens the freedom to keep and bear arms for the purpose of self-defense in the Second Amendment, which declares that the right to keep and bear arms shall not be infringed. As Justice Scalia affirmed in the majority opinion for District of Columbia versus Heller, the prefatory clause, a well-regulated militia being necessary for the security of a free state, does not restrict the operative clause of the Second Amendment, but rather gives a reason for why the operative clause.
So if I can interrupt, Counselor, thank you. I think we all agree that Heller recognized an individual right. We're all on the same page. No one's asking to overrule Heller. So my question for you is this. Did Heller say anything at all about the right to carry outside the home?
Well, Your Honor, it is true that Heller was, in that case, it was talking about the right to carry inside the home, where the right to self-defense was more acute, but it certainly left room for the right to carry outside the home. And I believe that cases like the per curiam decision in Caetano versus Massachusetts go to show that carrying for self-defense outside the home is also allowed, since Caetano was carrying a weapon for self-defense outside, and the court decided that she had the right to do so.
I agree with you in Caetano, but what about Heller? Is there any language in Heller that gives us this sort of room to make these sorts of decisions, Counselor?
Not directly in Heller, no, because the case was specifically for carrying arms inside the home, and it didn't go past those boundaries.
Okay. All right, you may proceed, Counselor.
Thank you. So many of this nation's founders advocated for an armed people capable of self-defense. And great thinkers before them, like Blackstone and Locke, believed that the right to self-defense is a fundamental part of human nature. History, tradition, and the modern understanding of the Second Amendment all affirm that keeping and bearing arms for self-defense, such as the kind involved in this case, is under the protection of the Constitution.
All right, Counselor, let's talk history. And I'd like to hear actually your co-counsel address this matter. I mean, what is your position as to the applicability of the Statute of Northampton and many of the pre-founding and post-founding regulations that seem to give credence to the respondent's argument here that reasonable restrictions on guns are kosher as to the Second Amendment? What's your stance on that, Counselor? Mr. Johnson, let me clarify.
Your Honor, yes, we do believe that these laws are put in place, but right now we're still thinking that what I mean is that my co-counsel, Leah Phillips, and I believe that they're too there's almost too much criteria to meet for an average citizen to achieve such a small minority. An average citizen is not going to be able to have all the necessary training, such as Robert Nash and Brandon Koch.
In addition to this, Your Honor, I think especially it's like the Statute of Northampton is it's like 300 years before the English Bill of Rights, which is much more of what the founding fathers based the Constitution on as they were forming it.
But didn't some of the states adopt the Statute of Northampton?
Some of the American states.
Yes, like I think North Carolina, if memory serves.
There were some restrictions on carrying arms in some of the states historically, but many more of those were more along the lines of carrying arms that in a manner that caused terror to the people, and not so much just ordinarily carrying arms for the purpose of self-defense.
Yeah. So for Mr. Johnson, how long has how long has New York had this policy in the books?
Your Honor, I believe it was since America's founding in the first writings of the Constitution.
The New York policy.
In New York policy. Unfortunately, I can't answer
that's
that.
okay. It's been around for a while, about a century or so, right? So I mean,
Right.
Isn't the fact that it's been around for a century a good indication that it's valid? Why is it all of a sudden illegal in 2022?
Your Honor, I believe that now there's become a much more awareness to the danger of firearms. In centuries past, the weapons produced have not nearly been as destructive.
Wouldn't that help the other side? Wouldn't that help the other side? If you're saying guns are more dangerous, we should have more restrictions. That seems to help the other side.
Well, Your Honor, we do have a lot of now current background checks to make sure everybody who is purchasing a firearm does have no criminal history. They're of the proper age. They have no history of mental illness. And these are excellent to have in place, but we cannot exclude those who don't have, of course, the proper necessary training, such as those who maybe never served in an armed force.
Okay, thank you. You may proceed, Counselor.
Counselor, you state in your brief, kind of going off what Justice Blackmun just said, that the New York proper cause law doesn't go as far as to completely ban all concealed weapons, but it makes it nearly impossible for the average citizen. What requirements would you suggest to be in place in order to be approved for the concealed carry license? Would it be such as what you were just talking about, like the background checks?
Yes.
Yeah. I think some of the regulations that it has now, like the background checks and requiring training and having no criminal history, are very prudent and reasonable measures to have to carry weapons. But those still allow the average person to get those things and obtain a weapon legally for self-defense, where New York's law only allows an exclusive group of people who are in an exclusive situation to do so.
So you're the petitioners of the understanding that if you are to decrease the standards of the New York statute, that the safety of the citizens will be upheld.
Yes.
I have a question for Mr. Johnson. What level of scrutiny should apply here, and does the state meet it or not?
Your Honor, we believe that it should apply to strict scrutiny. That would cover the entire nation. Right now, it's being held it's being held under rational basis review and strict intermediate scrutiny, just for the state of New York.
And do you believe that they meet even intermediate scrutiny?
I believe that they don't meet intermediate scrutiny fully, but they are adopting some of the similar policies, yes.
Why don't they meet intermediate scrutiny?
They wouldn't meet intermediate scrutiny because the law does not allow another way for people to exercise their right to self-defense. It puts the statute there, but it doesn't offer really a way around it, except for being in a very exclusive circumstance.
Okay, proceed with your argument.
So a potential objection to using Heller as a foundation for this case is that it only dealt with keeping and bearing arms inside the home, where the need for self-defense is most acute. However, nowhere in Heller is self-defense said to be exclusively limited to the home. And there's no reason to believe that the fundamental right to keep and bear arms for self-defense vanishes the moment the person steps outside.
Your Honor, New York's proper cause law turns the fundamental right to keep and bear arms for self-defense into a privilege only granted to an exclusive few. The New York law states that one must have a special case in order to obtain and carry a firearm and have this license. As shown when it says in Kachalski versus County of Westchester, it quotes, a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. This creates a class of people that the license is only offered to, which makes it a privilege. The wording, the right of the people, is used multiple times in the Bill of Rights in Articles 1, 2, and 4, showing that this right belongs not only to a privileged group of people, as previously stated, but to all citizens of the United States.
All right, I think you have time. Thank you so much. All right, respondents, can you please come back on camera and we will do the other side. Whenever you're ready, Counselor.
All right, let me just get my own timer here because, oh, I haven't, sorry, I do debate. This isn't what I'm used to. Okay. Your Honor, and may it please appease the court. In 2016 and 2017, respectively, the petitioners Robert Nash and Brandon Koch individually applied for unrestricted concealed carry licenses in the state of New York. Mr. Nash had participated in firearms training recent to his application and cited a string of robberies in his neighborhood as a reason for applying for an unrestricted firearm permit. However, under New York law, Mr. Nash does not fulfill the burden of proving proper cause because Mr. Nash personally was not affected by the robberies in his neighborhood and could not cite a specific identifiable threat to his life. Mr. Koch also mentioned his experience with firearms and self-defense, which means that Mr. Koch had already the means to defend himself, and Mr. Koch was never put into a circumstance where he would need a firearm for self-defense because he did not fulfill proper cause. Furthermore, Mr. Koch has already been authorized to carry firearms to and from work, providing him with this desired safety in his neighborhood. Under New York Penal Code 400, both men's applications were rightfully denied by licensing officers on the ground that neither man proved proper cause for unlimited.
Well, let's start right there, right? If he's already able to carry a gun for his job, right? What's the additional burden for the New York State for him to carry it when he's not on the job? Why is he trusted to carry a gun for X hours a day, but not Y hours a day?
Well, it's very different, mostly because like at a specific job, you're not really like leaving from that place. You're just like staying there. That is your occupation. However, to and from or everywhere around, there's also like an added like, is there really something that's going to happen to you like immediately? Like you can just say like, Bob is definitely going to come and shoot me, and I know that, and like then.
Yeah, but it's very rare that we have such specific threats. Doesn't the good cause standard seem very hard to satisfy? What if you have a general concern? You live in a rough neighborhood, and you don't know exactly who's going to kill you, but you have to walk through a rough neighborhood every night. Why shouldn't you be able to have a firearm to defend yourself?
Yeah, I mean, in this case specifically, like Saren said, like he does have a right to carry an arm to and from work, which would kind of cover a lot of that area while walking around his neighborhood. If he felt unsafe, then that does kind of cover a lot of that. And in addition, to kind of build on what Saren was saying earlier, jobs have additional requirements in order to carry a license. And so he had that background. And there is also a different level of accountability while you're on a job than when you're not. And so both the company would be responsible if something happened versus outside. It's a lot more personal and there's a lot less restrictions and liability in terms of that.
And I would also like to
Counsel, if I may interject, is for Counselor Williams specifically, do you agree that the Second Amendment creates an individual right predicated on self-defense?
Yes,
or no?
That is
okay, right. So then, could you see the petitioner's side here that a law which requires specific identifiable threats somehow infringes on that right? I could foresee situations where there is a girlfriend-boyfriend scenario, and maybe he hasn't been abusive but beforehand, but she just generally has been feeling unsafe, and there's been no specific acts of violence, and the girlfriend is not able to get a firearm there. It seems like under the New York law, she wouldn't have good cause to me. Am I incorrect in that belief, counselor?
I definitely can see an argument for that case. I feel like that there are other protections that both New York law and national law provide in cases where there is an abusive relationship. I feel like there are other avenues. I'm not trying to disrespect people's right to carry a firearm just for self-defense, because that is what all of the courts have established. However, New York does have a responsibility to its general population to ensure that people that do have unrestricted licenses and licenses in general, that they are properly going to take care of both themselves and they're not at risk for hurting themselves or anyone else while having that firearm.
Counselor, let's talk about Heller for a bit, right?
Mhm.
Heller said that the government can restrict firearms in sensitive places, right? That's where they use sensitive places. How would you define a sensitive place?
I think sensitive places allows for a lot of it's like not super defined by any of the court systems. So it is kind of something that is up to each individual government. Personally, I think like churches or spaces where children are frequently are like schools, churches,
Children are everywhere.
bars.
I believe the children of the future, right? They're everywhere.
Yeah, so that does provide a lot more.
Can the entire the entire island of Manhattan be a sensitive place?
I think depending on the circumstances, I think it could be considered, just because that is a situation where there are a whole lot of people congregated in one location.
The entire state of New York, the Empire State is all sensitive.
I don't necessarily think that the entire state can be considered a sensitive place. All right, so then
how do we draw the line, right? In other words, how are we supposed to draw this line between sensitive and non-sensitive?
Yeah, I mean, that's entirely up to the discretion of the government. And I feel like
the court have any role in second guessing that decision, in evaluating that decision?
I feel like there are avenues to keep the government accountable for its actions in any decision that they make, such as suing the government, like the petitioners are doing. So I feel like there are other.
So my question for Sarah now, if we start from the assumption that there are some non-sensitive places, right? We agree there's some places that are non-sensitive. Why can't the state allow carry in non-sensitive places, whatever those places are?
Well, I think the state has already allowed carry in non-sensitive places, just as target practices, shooting.
But only if you have, no, that's not carrying. That's going for target practice. That's you keep it in a locked box to go there. You can't take it out at any point. So my question again is, if we agree that there are some non-sensitive places, which I think we agree upon, why can't the state allow carrying in those non-sensitive places?
Well, if you do the cost-benefit analysis, any non-sensitive place can become a sensitive place at any.
So then everything's sensitive. So let's go back to the point. So the entire state of New York can be sensitive.
Theoretically speaking, yes.
You think that's a fair reading of Heller? That Heller even said there are some sensitive places doesn't imply that it's from non-sensitive.
No, I don't think that's a fair reading of Heller, because Heller decides that like one may hold arms within like the bounds of their home, and then also in non-sensitive places. Sensitive places are places where people will be at risk. Obviously, with firearms involved, every single like place with that is at risk. However, restricting non-sensitive places is like a way of protecting the New York's interest in trying to keep everything safe, because even if it isn't non-sensitive, it can be non-sensitive. So
look, I'm sensitive to your argument. No pun intended. Let's try a different approach. What's the strongest, this is for Flynn, what's the strongest piece of historical evidence you have in support of your position?
Yeah, I think the main point in both our brief and our oral arguments is that there's a lot of history backing proof that, like you guys mentioned earlier, that this law has been in place for a very long time. And there's a lot of history backing that both the founders and pre-English law allowed for restrictions of firearms.
What are some of those English law that you're referencing? Just give us maybe some of your top.
There was I'm totally blanking on the name right now. But I do remember that there was an English law that allowed for restrictions in like carnivals and places where people would most frequent. I think it started with a W. I'm sorry, I'm totally blanking on what it's called right now.
That's okay.
Well, let me ask you this. It's my understanding that the American right to bear arms is broader than the old English right to bear arms, which is more restricted. I mean, do you have anything on this side of the pond post-founding that supports your position in a historical sense?
Yeah, I mean, this law was later then adapted by several states, like the petitioners mentioned, and has been in existence for a long time. And there were a lot of support for militia regulations during the time where the militia was a lot more active and a lot more involved. And it has kind of lost a lot of its importance nowadays, but I feel like that still is an important context of the Second Amendment because the founders wouldn't have included it if it wasn't important. And so there is support of the fact that the founders and supported militia restrictions in terms of that was the traditional sense of when most people would be carrying a firearm would be in protection for a militia. So it gave context for the situations in which people would traditionally bear them to allow for such restrictions.
You may proceed, Counselor.
Okay. Proper cause, as defined by Kachalski v. Westchester, is where applicants must prove that they have, quote, an actual articulable rather than merely speculative or spacious need for self-defense, a similar burden to that of a restraining order. Antecedent to this case, the petitioners had been respectively granted the ability to use their handguns for outdoor activities, hunting away from populated areas, target practice, and others. Under District of Columbia v. Heller, the petitioners are already granted the right to keep and bear arms within the home. Yet this does still allow the government at the discretion to limit the circumstances of the right outside of the home.
Counselor, so is it the position of the respondent that the New York statute is not too strict and meets the needs of its citizens?
The New York statute is not too strict in the needs of its citizens because let's say it this way. It's sort of like this private versus like work thing. Like for work, there are assets that you need to protect that involve, so there are firearms involved. But at home, you need like the New York law is trying to force the petitioners to prove that there is something that they must protect within their home or something on themselves at all times, 24/7, that they to reason why they would need a firearm at all times, or it also known as a concealed carry license, unrestricted concealed carry license.
So it's your position that the law requires that they must possess an item that requires protecting in order to have?
So sorry. The law requires that you need to prove in danger. Like it doesn't have to be like on yourself. The like quote unquote thing that needs protected can be a person. You just need a proven danger. You can't cry protection from a situation that you are active in. You can only cry danger in a situation where you are in danger. And that is what Penal Code 400 is trying to prove through proper cause. May I continue?
So I see in your brief that you're arguing that intermediate scrutiny applies here.
Yes.
So you're trying to also say that the New York statute is not substantially more burdensome than it needs to be.
It is not, because it's like a restraining order. For a restraining order, you need to prove that there is some sort of like actual thing that is harming you that you need a restraining order against. And in this case, proper cause is going like, you need to prove that there is something that is actually harming you, so you need a gun 24/7.
And in a situation, a restraining order doesn't have an immediate, like deadly consequences. Firearms can have extremely deadly consequences, as we have seen over the past for a very long time. So in order to apply, like the government has an interest in keeping its people safe. And so adding this additional check on top of a background check to have a professional sit down and look at the profile to make sure that the person that is applying for a firearm actually meets the requirements necessary.
Which is also why proper cause is necessary. Sorry.
Counselor, Counselor Williams' question. If we apply strict scrutiny, do you lose?
No.
Why?
I don't believe so.
Why?
Because the government does have an identifiable interest in keeping its people safe. And although there might be some form of burden, I feel like that it does still allow both of the petitioners.
You're saying, Counselor, excuse me, this is the least restrictive means. This is the only way the government can protect its citizens.
I don't feel like that is the only way for governments to protect its citizens, because there are background checks, there are a whole bunch of other ways to go about this, but I feel like that is also an important
But doesn't strict scrutiny require from the least restrictive means?
Yes, you are correct. I'm going to take back my previous statement. I feel like that in addition, like, because it's the penal code incorporates like background checks and all of this stuff, but it has that additional aspect to it, which does keep the burden the same.
All right, I see you're at time. Thank you so much. If the petitions come back on screen and you have your 5 minutes rebuttal time, and we can begin whenever you are ready.
Thank you, Mr. Chief Justice. First of all, we'd like to point out a few things from the respondents' argument and their brief. The respondents say repeatedly in their brief that there were founder era statutes similar to New York's proper cause law, but fail to list any examples. There were indeed some restrictions on keeping and bearing arms during and before the founding era, but we think you'll find that these were mainly narrow restrictions on weapons that caused terror to the people. Ordinary firearms were common, and the right to bear them outside of the home for self-defense was left largely unhindered. And the respondents also based much of their argument on the 1328 statute of Northampton, which prohibited bearing arms in public places, as mentioned before, many common areas. Back then, it would be things like fairs and markets. But the statute of Northampton was veritably put in place in the Middle Ages, and the founders looked more to the English Bill of Rights as a template, which was written over 300 years after the Statute of Northampton.
But didn't some of the American states, I think North Carolina, adopt the Statute of Northampton?
That is correct, they did.
So isn't Northampton somewhat relevant then to how the framers would have understood it?
Yes, Your Honor, but since they were transferring to more of a modern age of course, changing times, changing weapons, and changing society, they had to find a more modern.
My goodness, that's what your friends on the other side are saying. We have AR-15 say we didn't have those in 1787. I mean, if we're looking to more modern rules, that seems to help your friends on the other side.
Even though laws somewhat similar to the Statute of Northampton in ways were in the states at that time, the founders still based the right that they guaranteed to all people off more modern things like the English Bill of Rights, and those are more relevant, even though the Statute of Northampton should be given some consideration. Things like the English Bill of Rights and what the founders thought around the writing of the Second Amendment are definitely more relevant.
Okay, thank you. May we proceed?
So, how would you reply to respondents' argument in their brief that there is protections in place to prevent discriminatory practices with the New York statute?
I'm sorry, I'm not understanding. To prevent discriminatory statutes.
Yes, so the respondent states in their brief that there's already protections put in place to prevent any discriminatory practices in regards to this New York statute.
Right. Okay, so so they are referring, I assume, to the saying that the proper cause clause isn't being discriminatory, but believe it is, since they really are only allowing a specific group of people that meets a specific group of expectations to exercise the right to self-defense that the Constitution guarantees to all Americans.
Okay. Can you proceed?
To address the respondents' concerns about gun violence and public safety, we would say that the studies comparing the relationship between gun violence and gun legalization are at the most inconclusive and contradictory, and that a change increasing firearm restrictions in a way that contradicts the Constitution would have to come through the amendment.
But counsel, if I can ask this question, if the evidence is sort of conflicting, right, we don't have a clear answer one with the other, shouldn't the answer be that we don't decide judges? Shouldn't the answer be that the legislature decides? Isn't that what we do in the face of conflicting evidence? If the court doesn't have a clear answer, we just defer?
Right. We would say that the changes to that would have to go through the amendment process. And,
no, I didn't say the amendment process. Good, smart answer. I said the legislative process. Why can't the New York legislature make this decision? They're accountable. We're not. We're judges.
Well, because the 14th Amendment would apply the rights guaranteed to Americans.
But we don't know. We don't know what the 14th Amendment means. In other words, given the fact that the science is somewhat conflicted and the meaning of the Constitution is contested, why don't we defer and uphold the New York law?
Your Honor, people still need to have that protection for their own personal safety. If we just took something completely away, we couldn't guarantee that they'd be safe. We still have things like our police force and security and surveillance systems, but that doesn't cover every bit of territory.
Okay, you have 10 seconds left if you want to your closing remarks.
Mr. Chief Justice, it is for the fact that New York has made the fundamental and natural right of a citizen to defend themselves by keeping and bearing arms in and outside the home into a privilege that is only available to a few under extreme conditions. We pray this court finds in favor of the petitioners and holds that New York's strict regulations and denial of these licenses are unconstitutional.
All right. Thank you very much. All right, everyone, please come back on camera if you can. That was excellent. That was really well done. The fact that we're asking such hard questions, I think, reflects the fact that we can answer them, right? We wouldn't ask the question you think you can answer them. You're well prepared. You're poised. You kept your composure. You didn't lose your cool. A couple of times you didn't know the answer to the question, and you said, "Your Honor, I don't know." And that's the best thing for you to say, because the worst thing to say is making something up. You make something up, you're in trouble. So saying, "I don't know," okay, maybe you lose a point or two, but you maintain the court's credibility. If you start making stuff up and just sort of going off on, you know what, you're in trouble. A few general points, and this is sort of advice for everyone. Watch your speed. We all do it. I do it. We have a tendency to run very quickly with speed. The only way to fix this is to listen to yourself speak. And trust me, it's painful to listen to yourself speak. I know you're all smiling. Record yourself and play it back and be like, "Oh man, look how I sound." You have to listen to yourself. And when you listen to yourself, you start picking up on little verbal tics, like saying like, and yeah. Drop those, right? It's very hard, but as you sort of transition from high school to college and college to law school, maybe one day, I think you're all in the ballpark, right? On that, or you're all on the train. Those little tics start to stand out even more, and you have to work on it. And it's hard. It's very hard, but with practice, you are able to reduce those sorts of tics. When you're getting ready for an argument, you should know your brief cold, and you should know the brief of your opposing counsel cold. Easier said than done, right? But if something's being asked, you wrote this in your brief, it's fair game. And it's a very common tactic of the judges, especially at the higher levels of tournaments, to really say, on page 7 of your brief, you wrote this. Or even worse, your opposing counsel wrote this. Do you agree with them? Right? And if you hadn't read the brief carefully, you don't want to think on the spot of an answer. Because one of the advantages of this tournament is you get the briefs in advance. It's not a surprise. You know who your team is. In real moot court, you don't have advance notice. You have no clue who you're arguing against. So at least you can use that to your advantage. I thought both teams were very strong. You're competing at a level well above high school students. You're competing at maybe a college moot court competition, maybe even a law school moot court competition, right? You're really above and beyond your years, which is special, and that's the reason why I like this tournament very much. I treat you, this is perhaps going to sound mean, but I treat you like my students. Reed and Ashley are my students. That they maybe will attest to it. But I ask you the same sorts of question I ask in class. So if you're feeling like intimidated or scared, just welcome to law school. Right, this is what you have to deal with. But I'm very proud of all four of you. You have so much potential, and I'm so excited to see what you all accomplish in the upcoming years. It's just the sky is really the limit for you all. I mean that sincerely. It's high schoolers should not be able to do this, but you did it. Ashley and Reed, anything you like to add?
Yeah, I think y'all did really great. Definitely above a high school level, just like Professor Blackman said. Like, I don't think I could have done this in high school. I don't think I could have wrote a brief and researched. So y'all are way above the level. I mean, y'all made really compelling arguments. And a thing I noticed was if you got a question that you didn't really know, you took the time to like really take the question in before you responded just off topic. And I think that makes way bigger of a difference in the answer that you give. And I think y'all did a really good job at that.
Yeah. Don't be afraid to sit there, pause, let us see the gears turning, and give that answer. I thought you all did a very good job. And then when I ask whether something applies, give me the why right after it. Just go right into it. Give me your legal reasoning. Legal reasoning and sources matter at this level. It really does. Good job, everyone.
And definitely work on the speed, because I have to work in it all the time. I talk so fast, and I think it's just a continuous thing that you always have to work on.
Yeah. I mean, what I find, I do a lot of moot court right now, and it's all a moot court round is having a conversation with the judges. You're just up there talking. Conversational, be likable, respond to their questions, and you will be an excellent advocate, and you can compete at any level. But other than that, I don't have anything.
Good job, guys.
Do you have questions for us? I'm always happy to answer your questions. Come on, you have some questions.
Well,
law school, anything in your minds?
Joke's on you. I'm not actually planning on going to law school.
Okay. You don't have to. There are lots of ways you can make your mark on the world.
But out of sheer curiosity, what would you have answered to the question that you asked me?
Which question?
The one that I like struggled on the most. It just like kept on making things up for, and then I don't know whether I got to it later on or not.
Reed, do you remember a question? I can't remember the question.
I don't remember all the questions I have.
You remember?
No, I
I think
don't.
she's probably referring to the restricted, unrestricted.
Oh,
I think it was the sensitive.
Oh, yeah, that's a hard one.
Sensitive.
Yeah,
It was
sensitive places.
Okay, I look. I've been here since 9 o'clock this morning, doing this all day. So I apologize. So the sensitive places question is very hard. It's a classic line drawing issue, right? The reason I'm asking this question is to make you draw a line, because once you draw the line, I'm going to push you over that cliff, right? The second you say yes to one of my questions, okay, that's the line that you drew, and I'm going to push you over that cliff. And there's not really a good answer. And I'll be completely candid. If you listen to the Supreme Court argument at the Supreme Court, the lawyer for the gun rights group, his name is Paul Clement. He was a former U.S. Solicitor General, one of the top lawyers in the world. His answer sucked to that question. Why? Because he realized once he draws a line, he's screwed. Right? Once he accepts a line, he can't prevail. So in a way, and I mean this sincerely, the fact that you were fighting my question wasn't like entirely wrong, because I think you knew in your head, like, once I answer Blackman's question, I'm in trouble. So there are going to be some questions, maybe Reed or Ashley can chime in from the perspective of a current law student, but there are some questions that you actually try to avoid. It's not always a good idea, but there's some questions where you're actually better off not answering. Ashley, Reed, what do you think? I don't know how to answer the question.
Yeah, usually when I get a really bad hypo or some sort of horrible line drawing test, I'd be like, well, I try to answer it to the best of my abilities or some sort of perhaps argument, but Your Honor, that's not the case here. And then I get back to my outline. I mean, it's that being said, you want to go down the places sometimes judges want to take you, but those will inevitably lead to places you don't want to go. So you got to come back at some point. And so answer it and say, but that's not the case, or, you know, what, that's not what we have here, and just try to get back to what you want to tell the court.
Yeah, I completely agree with what Reed's saying. It's like a fine line between wanting to answer what the judge is asking you, but also wanting to try to pivot out of it. So I think, just teetering the line and trying to figure out what's best for your argument is probably the best that I would say.
Yeah, it's a bit of a trap too, right? Because once you answer the question, you're asking for a world of hurt, right? You're basically walking into a chainsaw. So it's not good. So, for example, the Yankee Stadium line, right, or the subway line, or a college campus, right? I didn't get to this question. I think of Columbia University, which is in Morningside Heights, which is basically right next to Harlem in Manhattan. I'm not joking you. So one of the questions was at NYU. If you know where NYU is, in Greenwich Village in New York City, and there was actually discussion whether NYU is a campus. And the lawyer for the gun rights group was arguing about whether NYU actually had a campus. Why was he doing this? He didn't want to answer the damn question. So he was fighting. He said, well, NYU doesn't have a campus. I've been to Greenwich Village. It's a campus. There's purple flags everywhere, right? So you're not wrong to fight my question. And you didn't do a bad job. I think you were like resisting it respectfully, but you were resisting it.
Can I ask another question? Just like wasn't in Mr. Clement's response to that question, I see how you're saying it was bad, but didn't he kind of end with it does depend and kind of a perhaps and then move on?
Yeah.
Because I think he said something like it's down to the state legislature, the city legislature, whatever.
Yeah. Yeah. I mean, look, his answer was not the best. But you have to, as a lawyer or as a high school student acting like a lawyer, you have to know where your lines are and stick to those lines. Like, so when you're prepping for a round, you should know in advance, what are we willing to give up and what are we not willing to give up? And then you know where that line's going to be. And that way, it's not like you're sort of just thinking on the fly. I think Flynn, once or twice, you're like, okay, never mind. Yeah, you're right on that one, right? Which is not wrong, because I appreciate your candor. You are honest with the court, and honesty is always very, very important, right? Because that builds you credibility. I find you credible. But also, it's like, okay, Flynn just changed an answer after like 5 seconds. So you have to sort of prep in advance. What are you willing to give up? But always, if you find yourself you're in the wrong spot, give it up. Don't tie yourself, to a sinking rock if it's going to destroy your case. But Leah, you're right. Paul Clement kind of came back, but I was trying to make the point that it wasn't an ideal answer that he gave. They were literally fighting this NYU of a campus. Can you imagine at the Supreme Court? That's what you're fighting about. Ms. Weekly, anything that you want to bring up? No. All right. Well, if there's nothing else, I'm happy to. If the students can sign off, and we'll get ready for the next match in 14 minutes. But thank you all for your attention, and we'll be posting the scores by Monday or so. Thank you so much.
Thank you.
Thank you.
Thank you so much.
Thank you.
Good luck, everybody. Whew. All right. Let me turn the recording off.